joining us, and thank you very much for your guidance on the recent case of Dassault Aviation. It's met with some interest, not only from insurance lawyers, but also from worried commercial contract drafters who are keen to make sure that no unexpected things happen if there is an assignment. Could you tell us, please, what, generally speaking, the implications are of this judgment for insurance policies?
So it's an interesting judgment because it concerned a non-assignment clause in an English law contract, and the question was whether that prohibited subrogation as a matter of Japanese law. So the starting point might be, why do we care about this as English lawyers? The answer is because in trying to decide whether or not this non-assignment clause in an English law contract had the effect of prohibiting subrogation as a matter of Japanese law, Mrs. Justice Cockrell, who was looking at it on appeal from an arbitration judgment, was faced with the argument, well, the parties to the English law contract wouldn't have assumed that a non-assignment clause would catch subrogation as a matter of English law, so therefore it shouldn't catch Japanese law. And there was an easy answer to that, which is that Japanese law is slightly different in that where subrogation applies under Japanese law, the insurer doesn't bring a claim in the name of the insured party, but they bring it in their own name. So that would have been an easy answer. But there was a second possibility that was put to Mrs. Justice Cockrell, which would be that actually you can't assume that an English law non-assignment clause wouldn't prevent subrogation as a matter of English law. And that is quite an interesting idea, because I think, certainly as an insurance lawyer myself and most insurance practitioners would probably assume that to be the case. But Mrs. Justice Cockrell struggled with this, and she went on, having reviewed all the authorities, to say she wasn't prepared to say there was such a general presumption that an unassignment clause didn't apply to subrogation, either equitably or as a matter of contract under English law. She said there were some cases which went that way, and she could see the force in some sort of argument, but there wasn't a general principle, and she wasn't prepared to say there was one for fear of opening floodgates. And so that therefore opens up the question of whether or not those of us, probably myself included, that would, without giving it much thought, have just assumed subrogation wouldn't be caught by non-assignment clauses, might actually be wrong, and this might be open to challenge.
It does come as rather a surprise, I must say. It's not something that I think many insurance lawyers expected to see reaching this stage. The decision is subject to appeal, so we're yet to see whether anyone is actually going to take the point under English law. But it does give cause for concern about your contracts and the clauses in your policies and about how they might be affected. What practical steps can commercial lawyers take when drafting non-assignment clauses to mitigate potential unintended consequences?
I think that in terms of practical steps, when it comes to drafting, then the importance is being clear in your drafting. And if you want to specifically exclude subrogation rights from your non-assignment clause, then make that very clear. Certainly one of the elements of Mrs. Justice Cockrell's reasoning was the clause that she was looking at, the non-assignment clause, was very broad, and on the face of it, it did include these subrogation rights under Japanese law. That's a obvious practical step that can be taken at the contract drafting stage. If you're a little bit further on and you're looking at your global insurance policies, some things that policyholders might want to consider. One of the complicating factors of this case was the fact that you had the underlying contract in the case under one law, English law, and the insurance contract under a completely different law, Japanese law. And as we all know, contracts under different laws working together can cause all sorts of practical problems. So that's something to be aware of and think very carefully about, and possibly something that might be appropriate to review. And the other thing is that it's certainly something that you might want to speak to your broker about in terms of reviewing your policies, just in in case if you're concerned, and seeing whether a review of your policies can be undertaken and whether there might be anything that you might want to think about doing as a result, whether that involves some kind of notification under the underlying contract. And that was one of the elements in this case, that there was an opportunity to notify under the non-assignment clause, but that was never done. So that's another practical step that should be considered.
Yeah, I think it's yet another example of the perils of having competing legal systems meeting together.
Absolutely.
And you mentioned, the use of captives and complex global insurance programs, and that underlines that point. I have seen some programs where you don't have that, and well, chaos ensues, and it ends up on the desks of dispute lawyers like us. So thank you very much, and thank you also for your article. There's a lot more depth in that that people can have a look at if they want to know more. That's very helpful. Thank you both.